My name is Peter Hecht, folks. Welcome to yet another mind-blowing webinar from the folks at Magna Legal Services. I'm looking here, Perry. We've got, wow, we've already hit 52 participants, 55, 56, 58. You folks are definitely popular. Your social media ratings are going sky high. So 61 people here. For me, I'm a novice at this. This is only the 3,000th webinar that we've put on during the pandemic here at Magna Legal Services. So I'm going to just try and make sure I don't fumble this. But if you don't know who I am, my name is Peter Hecht. I am one of the co-founding partners at Magna Legal Services. I'm the head of sales and marketing. Surprise, surprise. And, we at Magna do a lot of different things. And when the pandemic struck, one of the things that really got shut down for us was our ability to go out there and meet and greet our clients. And what we do normally is we have these really fantastic educational and entertaining conferences in some really interesting locations with some really great folks like the people that you're going to meet today. But because of COVID, and I hate COVID-19, we're here in virtual reality. So I've got a small opportunity to speak to you and just tell you quickly what we do here at Magna before I pass the baton to Perry and this esteemed panel here. So if you don't know who Magna Legal Services is, we are an end-to-end litigation consulting and support company. We're based in Philadelphia. We have offices, in just about every NFL city across the country. And what do? We're an end-to-end services provider. So in discovery, we're doing depositions. And you might be thinking depositions, and I'm sure, Perry, you've taken one or two in your litigation career because you're famous, and everybody should know you at this point. But you're probably doing some virtually right from your living room, right? We do that too. So yeah. If you need to take a deposition, you can call us up at Magna. You can reach out to Candy Wood at our phone number is 866-624-6221. I did it, Rachel. I couldn't help myself. And you can schedule a virtual deposition. We don't charge for the virtual platform. It's complimentary. We have all kinds of training. If you're afraid to use your exhibits, we can show you how to do that. And then as you're moving through the life cycle of litigation, you're thinking, hey, what's my case worth? What will prospective jurors, and we're going to hear a lot about that in a few moments, think about my theme, or how do I develop my theme? I can't do a bricks and mortar mock trial or focus group. Well, Rachel and her team at Magna Legal Services, they actually invented the virtual mock trial 15 years ago. That's right. It's patented, and we're the only ones that have it. It's called Jury Confirm. So if you want to test out your case after you listen to this great session, reach out to Rachel, reach out to Candy. You can give me a call. We'll show you how to do up your mock trial or your focus group virtually with all the analytics, all the instant feedback, and all the expert insights that you're going to get from somebody like Dr. Colangelo. So that's kind of my infomercial here. I hope I didn't embarrass anybody, but I just wanted to get it out there. The things that we're missing are our next event is supposed to take place at the Aria Hotel and Casino during March Madness. It's scheduled for March 24th and 25th. It's a great event, and we are keeping our fingers crossed that something will change, and maybe we can get there. If we can't get there, October 24th and 25th, we'll be at the W in South Beach. By then, I think everything hopefully will be looking fantastic. If you're looking to get involved in donating some money through participating in some webinars to Children's Hospital of Philadelphia, two things for everybody to think about. We've got a fundraiser, a Peloton ride. For everybody that signs up for the Peloton ride on Friday, it's on the 23rd at 11:30 a.m. We're going to donate $25 in your name to Children's Hospital of Philadelphia. It's a fun ride. We all get to do it together on the Peloton. Join us there. And then if you want to see a spectacle of a webinar, we're hosting the first ever Lunch and Learn competitive eating webinar. We're going to raise $1,000 for Children's Hospital of Philadelphia. And 5 Magna eaters are going to compete over 10 minutes to see who can eat more White Castles than anybody else. And there's going to be an educational component. And the not real Guy Fieri is going to host and judge. So those are all my plugs for Magna Legal Services. Perry Visconti from Lathan and Watkins, coming right out of Costa Mesa. You are a legendary trial attorney and litigator. You should be on speed dial when somebody has a bet the company case. So I pass the baton to you, and I'm looking forward to listening to your session.
Well, thank you, Peter. That was nice of you. Welcome, everyone. Happy you could join us today. Let me introduce you to our panel. First, we have Connie Mateo from Pfizer. Connie, tell us a little bit about your background and what you do at Pfizer.
Sure. I've been an in-house lawyer for about 14 years now, and like everyone in the Pfizer litigation group, I'm a generalist. So I handle everything from product liability matters, NDLs, to antitrust cases, to commercial matters, to slip and falls, and even on occasion auto cases. Our group handles everything with the exception of intellectual property enforcement, tax, and employment litigation.
Wonderful. And our next panelist is Keith Newberry. Keith is the Vice President, Chief Intellectual Property Counsel at Edwards Life Sciences. Keith, tell us a little bit about what you do.
Sure. My practice is focused on all aspects of intellectual property, including the normal patent and trademark things that you would think about, but also global intellectual property enforcement, a fair amount of trials, jury trials in the United States. And also because intellectual property is such a big part of the world at Edwards, we've also undertaken from time to time product liability defense, employment actions, and other things that would have a jury in the United States. I've been a lawyer since 1993 and have been at Edwards since 2007 and have a group of highly dedicated group of about 18 people that work on our matters internally. Thanks.
Thank you, Keith. And by the way, Keith and I used to work together about, 25 years ago, 30 years ago? It's been a long time. Anyway, our third panelist is Rachel York. Rachel, tell us a little bit about your background and what you do.
Absolutely. So I'm the Managing Director of Jury Consulting here at Magna. My background is in legal psychology. So I have a PhD in cognitive and social psychology, applying those concentrations to the study specifically of jury persuasion and jury decision-making. So our group, as Peter mentioned, does pretrial jury research, strategic consulting, helping with voir dire and jury selection, and monitoring trials and shadow juries for clients in all types of cases around the country.
Wonderful. Thank you, Rachel. Well, today, as you know, we're going to talk about the impact that the coronavirus pandemic has had on the public's attitude towards jury duty, corporations in general, and specifically the life sciences industry. As most of you know, a lot of the trials that are taking place right now are virtual. Some are doing hybrid trials, which are partially virtual. And there are actually a few courts that are doing in-person trials. And one of the things that Rachel and her team has done is put together a study of potential jurors' attitude and thoughts towards the life science industry. And Rachel, tell us a little bit about what you found in your surveys and your study.
Absolutely. So just to give everybody a little bit of background on what these surveys are and what they have encompassed, we have done now actually 4 rounds of survey data, but today we're going to be sharing data from the first 3. We have been conducting sort of longitudinal data since mid-March, now with over 3,000 people, providing information on their willingness to serve on jury duty during the pandemic, as well as their own personal experiences related to COVID-19. And we've since done 2 additional nationwide surveys, one in June, one in August, in which we, again, we're focusing on issues surrounding jury service, but also looking more broadly at juror attitudes towards corporations in general, specifically the life sciences industry, that we know will have an impact on the way that juries approach litigation. So we were looking to see, has the pandemic created material changes in the makeup of juries around the country? meaning should litigants expect to see jury pools that look different? And what we have found is that, not surprisingly, there are a large contingent of folks around the country who are relatively hesitant to serve on an in-person jury, meaning showing up in a courthouse, being in a courtroom with other people. 40% of people around the country said that they have health or safety concerns that would make them either less likely to show up, or if they do show up, to request dismissal for health or perhaps financial hardship concerns. Another 28% of our pool has said, I'm just not sure, and probably dependent on when they got a jury summons, what the sort of COVID landscape looked like at that point. But then a solid third of our folks said they did not have any concerns or hesitations about jury service. We have seen some consistent patterns in the types of people that are more or less hesitant to show up for jury duty that I think will have a significant or may have a significant impact for litigants. Specifically, people who are most hesitant to appear and we are seeing least likely to actually make it through the voir dire and hardship process and be seated on panels are those that we would traditionally consider more plaintiff friendly. So these would be jurors who are more politically liberal, people who have any type of vulnerability, meaning health or financial hardship. Lower income individuals were less likely to report for jury duty. People with young children at home, which is not surprising. A lot of people these days are dealing with virtual learning, kids at home with no childcare options. And also the millennial generation is less likely to be able to serve in their reporting. And this, I think, makes a lot of sense when you think about it. The millennial generation right now is the one with young kids. They also are less established in their careers than other generations. And so they have been among some of the hardest hit financially with layoffs and furloughs. So when they're getting jury summons right now, they're saying to the judge, I cannot afford to take off 2 weeks of work. At this point, I've just gone back to work after a furlough, which is affecting jury panels and shifting them a bit to what we would traditionally consider more defense friendly. We are seeing older, more established jurors and more politically conservative jurors who have no hesitation and are actually making it onto these panels.
So Rachel, that sounds good for corporate defendants. Did any of your findings cut against that?
Yes, so that paints a bit of a rosy view of what corporate defendants might expect. But we do have, of course, some findings that are more on the negative side. So I'm going to skip past this and go straight to this concept of juror vulnerability that I mentioned. We specifically asked in our survey whether people around the country felt more vulnerable now since the pandemic, the same, or perhaps safer. And 52% of our sample has said they now feel more vulnerable than pre-pandemic. 29% says it's had no effect on them. As you can see, a very similar number to the 32% in our survey who said, I have no hesitation showing up for jury duty. Interestingly, 19% have said they're now feeling a bit safer because they're more aware of what risks are out there and how to protect themselves, for example, from contracting COVID-19. But the problem here is that, as I alluded to earlier, a vulnerable juror becomes more susceptible to traditional plaintiff strategies. Now, when we're talking about patent litigation, this can differ depending on the relative size and deep pockets, if you will, of the two companies, but you are often still dealing with maybe a smaller company versus a larger corporation. So these vulnerable jurors who have kind of a sense of lack of control and are personally struggling, either health-wise or financially, are very susceptible to strategies like Reptile, which I'm sure you're all familiar with, which is get a jury feeling unsafe, insecure, and out of control, and they will lash out at a corporate defendant at what they see to be some type of bad behavior. And in lashing out, they try to get the attention of that defendant with a huge jury verdict. And that's where we see this sentiment coming in, where 84% of the people that we've surveyed around the country agree that juries today need to be the guardians of the community, forcing companies to change bad behavior with large damage awards. So this statistic to me is pretty staggering. And we know that a more vulnerable juror is more punitive in this regard. So, some of these points here definitely cut against those positives that I mentioned earlier with the makeup of juries. On the whole, our population is certainly more vulnerable, perhaps a little bit more plaintiff leaning. I did just want to specifically mention, we asked jurors about the recent $1 billion jury awards that have been publicized. We've all heard about them, read about them, and prospective jurors in future cases have read about those verdicts too. And we wanted to know, do people think they're too high, about right, or are they just not aware? So a little over a third of our jurors feel like $1 billion verdicts are too high. That's unrealistic. But another third indicated that they feel like $1 billion award is about right. 6% even felt like that's still too low or ineffective compared to a company's profit. So you've got a substantial portion of the jury pool with that sort of guardian of the community, very large damage award sentiment coming into the courtroom.
Great, thank you, Rachel. Connie, any thoughts about the survey results?
Well, in some ways, they're not surprising, because I think for years now we've seen negative juror attitudes towards corporations. But this last graphic in particular is very disturbing to me, that nearly 40% either thought $1 billion verdicts are about right or too low. I mean, that's crazy. And as someone who works in the legal department at a corporation, it is very disturbing. And it just hammers home that as corporate defendants, we really have to think about our perception generally and really take steps to turn jurors around. We definitely are coming in severely disadvantaged. And Rachel, I had a question about the survey results, particularly the 84%, the reptilian side.
Mm-hmm.
Were there differences between gender there, or was it across the board, the 84%?
That's a great question, Connie. When we initially ran this data, we did not see statistically significant differences according to demographics. We've since collected more data on this question. So now that we have a bigger pool to draw from, we'll certainly have to go back and do another analysis to find out, as you're wondering, do women feel this way more than men, or are there differences that litigants can look out for in people that might be even more likely to espouse this feeling?
Keith, how about you? Do you have any thoughts on the results of the survey?
Sure. I think the anti-corporate bias is something certainly to be aware of. And we've had a couple of trials where the other side could have been viewed as kind of a collection of business people acting in a corporate manner. And I think the jury kind of held that against them a bit. And if you ask yourself, what's the gold nugget, or what's the practice pointer here? I think the practice pointer is, don't go into a trial as a corporation. Go into a trial as a collection of personalities, your expert witness, your business witness, your face of the company. Talk about the good things that you do that are personal and real. And if you have experts that have practiced and have done things to combat COVID, have volunteered, have done things at their hospital, I think you blow right past this corporate bias, because your side can become personal to the jury. and they don't think of you maybe so much as a company anymore. They think about your side as a group of people with a common mission. And so that's how I would kind of think about that.
Keith, that's a really good point. I tried to do that in my jury trials, and in one of my recent trials, it was for a very large corporation based in China. I put the CEO on the stand first as my very first witness. And I had him explain how he worked there for 30 years, worked super hard to get customers, built the company up into the large corporation that it is today. And I tried to make the trial about him, not some giant company that had a lot of money. And the jurors afterwards said, we really liked him. They felt like it was him against the other side, not his company, because they realized he had a personal invested interest, that he had worked so hard his entire life, basically, to build this corporation. So you're right, making it you have to personalize these big life sciences companies so that jurors understand it's people behind them. It's not just a big company with a lot of money. So Rachel, tell us more about your survey findings. For example, big picture, generally you read a lot about how people distrust or dislike large corporations, or that they have a lot of money. Particularly, you hear about cases where these large corporations get sued in another state. Tell us a little bit about what you found in your research about jurors' views, both pre and post pandemic.
Sure, that's one of the questions that has been at the forefront of our minds on the jury consulting team at Magna. Has the pandemic made perceptions of corporations better, worse, or remain the same? And as you can see here, 54% of our sample around the country indicated my views of corporations have remained the same, for better or for worse. And then we have about a quarter of folks, a little less, on each opposite end of the spectrum. 23% of the people we surveyed said views of corporations have actually improved since the pandemic, because they have this sense that everyone is suffering, including businesses who have had to shut down, lay off employees, change their operations protocols, shift the way that they operate, taking everything virtually. So there's a sense that, even corporate America is suffering. We're all in this together. However, another 23% has the opposite view, where they've indicated that the pandemic has only highlighted that concept that we are all familiar with in the litigation space. Corporations are prioritizing their bottom line over the safety of their employees or the public. So these folks are saying, my views of corporations have gotten worse, primarily because I've viewed how they've operated during the pandemic. We were curious specifically whether views of US versus foreign-based companies have changed. Perry, you just mentioned, representing a defendant based in China, and I know that happens often. We're dealing with foreign-based companies in US litigation. 47% of our sample indicated that they now, since the pandemic, prefer US-based versus foreign companies. And that, I'm sure, has a lot to do with media coverage surrounding the pandemic affecting people's general perceptions. However, almost half, 44%, say, I really have no opinion. It doesn't matter to me where a company is based. This next statistic, I think, is telling. We have generally found that people around the country are optimistic about the economic recovery. The stock market bounced back faster than people expected. And so there's this general sense that we will get back to a sense of new normal, whatever that is, after all of this. But while 20% of our sample respondents said, yes, I think all businesses will eventually recover, 56%, very large contingent, feel like big businesses will recover, small businesses may not. And I think this is interesting to consider. I'm sure that many of you in the audience are dealing in litigation where it's often business versus business, but typically there's a disparity between, the size of one or the other. Smaller companies might be able to play up this sort of David versus Goliath theme that we see sometimes, in that, corporate America will continue to thrive no matter what happens. And jurors won't necessarily hesitate to continue with these huge jury verdicts that we've started to see over the last decade. They might think twice about a large verdict against a smaller company because they've seen how things can significantly impact smaller businesses. So that, I do think, is a pretty interesting finding. We also specifically wanted to know whether the financial impact of the pandemic that prospective jurors around the country have felt personally might impact their views on damages. This is promising, and that 69% indicated, no, my own financial state will not affect my views on damages in a case if I were a juror. However, those of you that have tried jury trials probably recognize that that number is inflated, meaning people earnestly want to believe that they can set aside their own personal issues and be objective. But those things certainly do start to creep in, and they do filter the way that people perceive litigation and think about damages. So cautiously optimistic with this statistic, but you've got 21% of people around the country freely acknowledging that they would be more sympathetic to a suffering plaintiff if they were struggling financially. And then finally, we were also curious whether people's views or what they've read and heard in the media about how a company has operated itself, handled employees, handled the public during the pandemic would affect their views of that company in the context of a legal case. And 55% said, yes, I could see stories about what a company has been doing during the pandemic affecting the amount of damages that I might assess against them in unrelated litigation. So, this could certainly cut both ways. It could be a positive for some companies who have been in the news out there directly battling the pandemic. Could be a negative if companies have gotten bad press.
Thanks, Rachel. Connie, what do you and Keith think about those results?
I think it's going to be very interesting to see how this pans out. I think for us, our jury trials, we don't have any jury trials currently scheduled. A lot of our matters have been delayed or stayed because of COVID. We have more matters that are now in private arbitrations or other types of arbitration rather than before juries. But it goes back to the fact that as a corporation, we're always entering the courtroom, I think, at somewhat of a disadvantage. And we have to take steps to earn the credibility of the court and then, of course, to earn the trust of juries. And I think that starts with the team we put together. And again, going back to what Keith said, it's building a narrative, building a story that's going to resonate with jurors. And part of that is having a team that's representing you that can tell that narrative in a compelling way. And they need to be, a likable group of people who not only can convey the story, but they can represent the company in a way that people on the jury are going to feel as if those lawyers are credible lawyers. They seem like, caring, nice people. And as trite or as trite as that sounds, I think it goes a long way. We had a jury trial, I'm going to say 5 or 6 years ago, in a piece of litigation that had been going on for many years. It's an old mass tort, and we had tried a case in a fairly it was a bit of a challenging jurisdiction, and it was a challenging case because it was a very serious injury. And because it was a case where there hadn't been a trial for many years, and I guess I can say it was in the diet drug litigation, a number of the diet drug lawyers who had historically had cases came to watch our trial. And several of them, after the trial was over, said that the best thing that we did in that trial, which we won, was that we had two people who were our lead trial lawyers who were so likable that the jurors loved them, and they loved the story that they told, and they were so credible that overcame any bias that jurors might have had, particularly given diet drugs.
Yeah, I think Connie, those are great comments. The takeaway that I have from these particular statistics is that for the next year or two or three, while COVID is fresh in the minds of jurors, I think you've got kind of a free chance in a jury trial to hit a double without the other side even really interfering. If you show up and you kind of have an opportunity to create a bonding moment between your company people and the jury by talking about what the company did well during COVID. It's not like the other side is going to stand up and cross-examine on that issue, right? If it's a patent case or a product liability case, it's kind of a free thing that you can list the great things that your company did. Maybe you didn't lay off anybody. Maybe you made arrangements to job share. Maybe you immediately put everyone into remote circumstance and sent them free computer monitors. Edwards did that because we're concerned about their health. You have a free 10, 20-minute window maybe to tell a story that the jurors can think, yeah, that happened to me too, or I wish that would have happened to me. Those guys seem like they're doing something good. And it seems like a lot of the jurors would respond to that based on these statistics.
Yeah, good points, Connie and Keith. I couldn't agree more. You know, I was lucky enough during college and law school to work for a plaintiff's lawyer. So I was able to work on the other side and see how they perceive. And it was great. They loved getting a big corporation as a defendant, especially an out-of-state company, bringing them to LA, suing them, talking about how rich they were. And I learned from, you know, a very famous plaintiff's lawyer, you know, how they think and how they try cases. And they really personalize the cases. And now being on the other side, what I've seen and learned is exactly what Connie said. If you come in, particularly now in this pandemic, when everybody's stressed out of their minds already and afraid they're going to get sick if they go to an in-person trial, if you show up and you are super credible and nice and professional and organized, and you know how to use your technology perfectly, and you are likable by the judge and the jury, you have, you know, such an incredibly higher chance of getting a great result. And I see it over and over, how people come in, they can't use the technology right, they're mean, they're not likable, and, you know, we're seeing different results now, and you know, it's a new world. Just like Connie said, we're seeing a lot of arbitrations, bench trials, virtual trials, some hybrid trials, but very few in person. And in some of those in-person trials, there's been mistrials recently, you've probably heard about. So you know, those are the kinds of, I think, best practices you have to think about, even more now during a pandemic. So let's see if Rachel, anything else you want to add about your your survey and what you're seeing out there, and, you know, just in general about the life sciences industry or large corporations?
Sure, absolutely. I also just want to note that I couldn't agree more with all of the points that you just made from a jury perspective, particularly, Perry, your point about using technology and being prepared to use it well. Jurors are so appreciative of a well-prepared, efficient attorney presenter who uses technology and does it well. They love demonstratives, they love visuals. It helps keep them engaged, it helps them learn and remember. And if they see that you are prepared, you've put in the work, jurors are very impressed by that. And I often find that a corporate defendant, by showing the jury that you're giving them actual facts, information, data, can win them over, versus a plaintiff who often is telling a very compelling but more emotional story. So if you're sort of highlighting for them, we've got evidence to show you, the jury goes, wow, I really appreciated that they had a lot to put in front of this, in front of us. So I think those points are absolutely spot on. We were talking a little bit just now, Keith referenced this concept, didn't call it by name, but it's this sentiment that based on what companies out there are doing right now to benefit the public in various ways during the pandemic, can create this more positive view of those companies overall that might very well last a good amount of time, and that defendants, even a year from now in trial, can certainly remind a jury of. And this causes what we call a halo effect. So it's kind of this concept that if you're out there getting good press, you're doing good work now, people are appreciative of that, they're going to be less critical, more positive in the context of litigation. So we're absolutely seeing that, not at all surprisingly, with frontline healthcare workers. People are saying, I'm very concerned about their health and safety. I have greater compassion for healthcare workers now than I did pre-pandemic. And I think more importantly for litigation, 60% of people around the country say that they will be less critical of healthcare workers post-COVID. And I think that results from a greater understanding, greater awareness of what it is that healthcare workers do. We are expecting that this might translate probably to a less intense degree to the life sciences industry in what we would call more of a ripple effect. So I don't think that, a company would probably get the same halo benefit that, for example, a nurse or a frontline doctor would, but absolutely sort of being grouped in to that same space and being grouped into companies that have been great corporate citizens during the pandemic, as Keith mentioned, giving people free computers. Where I live, Comcast, the cable provider, has given families free cable so that children can do virtual learning. So things like that will create this sort of positive ripple effect that I think corporate defendants can certainly take advantage of. And we're seeing that already a little bit in people's current views of, for example, specifically pharma companies. No surprise that there has been publicity out there over the years that has caused a little bit of distrust or negative feelings among some jurors towards pharma. But this statistic is indicating a relatively positive view. So you've got 52% of the panel here indicating a favorable view, and 26% said neutral. So only 21% of our sample currently feels like they have unfavorable views. And I think that is already highlighting this sort of halo benefit. Now, it's not all sunshine, unfortunately. So we do still see some of these pervasive kind of sentiments that jurors bring into the courtroom with pharma and medical device companies, people subscribing to the plaintiff theme that pervades all litigation, not just in life sciences, but it's this idea about profits over people, profits over safety. So people have an idea that companies are, of course, more concerned about profits than really improving public health. So there is that sort of healthy skepticism that we're still dealing with. Although the statistic that we have here, I think, is promising. This is a pretty specific question we asked. We wanted to know, do people think that doctors and healthcare workers are pressured or incentivized to use particular drugs rather than choosing the best drug? This has been a theme that we've seen in some recent litigation. And most jurors, by and large, said, no, I don't think that that's actually the case. So sort of some mixed results, some hangover, perhaps negative attitudes still out there, but definitely starting to see a shift and perhaps more positive views.
Thanks, Rachel. Connie, Keith, what are you seeing in your industry? in terms of this halo effect and people's perception of large corporations?
I think the industry, the pharma industry at least, has tried to take steps to become more collaborative during this crisis, and to highlight transparency and really putting science first. And I think that may increase this halo effect in terms of the way in which pharmaceutical companies are perceived by jurors. I think a lot of companies are taking steps like Rachel described in terms of measures to help employees and measures to help communities. I know at Pfizer, we have done a number of things to help communities, and taking funds that were going to be used for events that can't occur, and taking that money and giving it to communities and where there is need, whether it's to healthcare workers or to other charities in the area. I think those are the kind of things hopefully will resonate with jurors, that pharma companies are taking this moment and really making the most of it. It'll be very interesting to see how this shakes out. And I'm not sure that, I think one of the things that I think is going to be the challenge is, again, this is a very distinct moment in time, but it also happens to be at a period in time where I just don't see in the near term many pharma companies getting to juries. So it'll be interesting to see how long the so-called halo effect will last.
Yeah, I think people will remember this for quite a while. And with regard to the medical device side of things, Perry, I think it doesn't end up on TV or on the news as much as the pharma thing. The pharma aspects, everyone's talking about a vaccine, and everyone's talking about different treatments and how the companies are responding in a quick way and trying to get things done. The medical device industry certainly is doing that as well. It's just a little less publicized. But that doesn't mean that if you show up in court and tell that story, I think people will still respond. For example, at Edwards, we make many sensors for the intensive care unit where patients would end up. And we had, just like any other company, extreme demands on those products, and we did everything we could do to satisfy that and make sure that the patients got treated. It wasn't a financial thing. It was a question of, you've got patients in need, and you've got to get, you're having to supply something that you had no idea you had to supply. You had no plan to make this many things. You had no people available to do it, but you turned everything upside down and got it done. I still think that for a long time, people are going to remember that and respond.
Yeah, good point. Thank you. Pre-pandemic, I like to tell this story about a mock trial that happened a long time ago, because it illustrates one of the problems of being a large company, being sued in a small town outside of your sort of home state. I had worked on this very large case, and we had done some mock trials, and we were watching the jurors deliberate. And they got off the merits of the case, and they started to discuss how much money they thought this company had that was a defendant against an individual. And they decided, look, let's just rule in favor of the individual. Let's hit the company with a really large amount of damages, and all that money will come to our state and we'll benefit from it. So this will be better for all of us. I mean, it was crazy how off the rails they had gone. And it was all about a big company with a lot of money, and they had completely lost their discussion of the merits of the case. And when you see that in a case that you're working on, it's pretty scary. And, there's a lot going on in the world right now, between the election and, what's happening socially and the pandemic and everything. And, Connie's right. I mean, right now, criminal cases are going and getting priority, obviously, but a lot of the large civil cases that are long jury trials where you need a lot of jurors in person, those are getting kicked over frequently right now. And we expect them to probably be continued again and again because of the backlog. So it'll be interesting to see how this plays out, but it is a different world. And you have to think about how people are feeling right now when you go try a case, because it is different than it was clearly a year ago, where we prepared for trials somewhat differently. Let me pause there. Rachel, what else can you tell us about what your survey found? Any sort of final comments about it that you'd like to take us through?
Sure, just a couple of final and more specific findings that might be of interest to some of our audience members. We were curious about warning labels. Warning labels are often an issue in product cases, even outside of the life sciences industry. And we were wondering, are people who are being theoretically more cautious in their daily lives now, have feelings about warning labels and heeding them changed? So we asked people specifically how seriously they take warnings on pharmaceuticals and medications sold in the US. And as you can see, by and large, people take those warning labels very seriously. I think much more seriously than they do on your average product, in which people often indicate on juries that we do, who reads that stuff? Nobody reads those warnings, but on medications and arguably medical devices, they're much more important. This, just to point out, is not really a change from what we saw pre-pandemic. These numbers are pretty consistent. So it looks like people are continuing to take those labels seriously and not any more or less so. We also were interested in people's sort of anxiety levels about exposure to chemicals or adverse health effects from any kind of exposure to some type of what could be a harmful substance. And we asked how concerned people are right now about exposure to chemicals, chemical compounds, and negative health effects related to that. As you can see here on the left, 83% of our sample said that they were either somewhat or very concerned. This is an increase from what we were seeing pre-pandemic. So it seems like with greater awareness of the coronavirus, how it transmits, how long it can live on surfaces, all of that sort of awareness and news that we're getting constantly has made people concerned about, quote, these exposures to negative things in our environment that could cause harm. As you can see on the right, the vast majority of people around the country believe that exposure to any amount of toxic chemical is dangerous to human health. This would be really relevant to folks that do asbestos work, for example, that concept that even one fiber of asbestos can cause harm. So this is sort of the sentiment that we're up against, that any exposure can be harmful. And people are somewhat hesitant to believe scientific testimony that says otherwise. It says, there are certain levels of exposure to chemical compounds that do not cause negative health effects. A lot of people said, I'm likely to believe that scientific testimony, but a good chunk of people also said, I'm not at all or not very likely to believe that. So I think that's important to think about when you're presenting your experts and scientific testimony. People are skeptical. And even when you've got the most credentialed expert up there walking them through the science, there is a bit of a wall. There's this big hurdle to get over with many jurors. And obviously that's something that can be explored through the voir dire process, finding out who does have that type of sentiment and putting them at the top of your strike list if you're dealing with a case in this realm. So I'll stop sharing the slides. I wanted to add on, Perry, to your comment about the mock trial you did long ago that got away from the merits of the case and that just started talking about the company. Just a year ago, right before all of this happened, I was involved in a patent dispute. It was more like a contract case because it dealt with licensing between two pharmaceutical companies, one bigger, one smaller. And we didn't tell the jurors anything about damages. We had them hear and discuss just the liability case first. And on the liability case, everybody was with the big pharma, the defendant. You know, they didn't infringe. And then when they heard what the plaintiff's ask was, they said, that's it? We know that this big pharma makes X billion dollars on one product alone per year. And why don't they just write the check? What are we all doing here? That was the sentiment that they had. And they all flipped and said, oh, well, then I just give them the money. Can't, which is really disheartening. Keith's laughing. It sounds crazy, but this is the sort of thing that we deal with juries. Of course, there are ways to get around that and to deal with that. But I thought your point, Perry, was very well taken, and we continue to see the same even as recently as this year.
That's a great point, Rachel. And what a lot of lawyers try to do is preempt those issues. So, in one of my trials, I was in the South, in this tiny little town, and they were all local lawyers, and they had brought in, lawyers from out of town to kind of support them behind the scenes. And the first thing they said in opening statement is, Perry from the other side is from California, to try to get the jurors, biased against me, that I was an out-of-town lawyer. And so what I've sort of learned over the years is I think about what the other side's going to do, and I try to preempt all of those in voir dire or in my opening, or whenever I get a chance. I raise, look, the other side's probably going to try to do this. They're probably going to try to point out we're a corporation, or we're a big corporation with a lot of money. Don't fall for that. That's not what we're here to do. And by raising the issue, I got to control the narrative rather than letting them control the narrative. And you kind of set them up where if they do go forward and try to get the jurors biased against you because you're from out of town, or you have a lot of money, or you have a lot of employees, or you engage in things that not everybody loves, you get to control the narrative and call them out. And if they do it, then the jurors are expecting it. They go, oh yeah, they're trying to make this about how big the defendant is, not the merits of the case. So there's a lot of things you can do, that Connie and Keith mentioned earlier by, preempt the issue, you set the narrative, you be credible and organize and set the other side up to step right in and make it about, something that the jurors are expecting. And it really can be an effective tool in going into what might be a hostile or difficult environment where you don't want to be. Connie and Keith, any final thoughts on the great research that was done by Magna here?
I think it'll be very interesting to see it in practice in terms of how juries react. And it really was very interesting to hear it and to see the statistics here. And I look forward to seeing how they play out in a real life trial.
I think it will be interesting to see, depending on how COVID plays out, if we enter a scenario where there is no vaccine and COVID is in the background as like a slow burn, but life kind of goes back to normal a bit, it'll be interesting to see if the makeup of jury pools really changes a lot. Do the folks over 50 years old all of a sudden not show up to juries at all during that if that scenario comes to pass? And do we end up with a lot younger juries? It also suggest, I don't know if it's a question to Rachel, I don't know how she could figure it out, but I wonder if jurors will be less willing to take a longer time to decide a complex issue. Will they feel that sitting in a room with 6 to 11 other people or 5 to 11 other people is somewhat not preferred or dangerous? So let's make a decision on this case right now. And I don't know what kind of questions you'd ask Rachel to get to the answer to that, but that would be a natural concern, I think, that there would be a rush to judgment, perhaps. Thank you.
Absolutely. Yeah, I think that's an excellent question. What I have seen in person, we've started going back to consulting on jury selections in person recently, is that by the time the jurors make it into the courtroom, they have already been screened for real COVID-related concerns, meaning any health concerns, anxieties, if they're very at risk. And then even if they make it through that health screening, that if they have financial hardship concerns, I've seen judges being fairly liberal these days with letting those folks off, meaning they're not pushing it. And so people that seem to have those major concerns are not making it through those initial screens. So by the time you are picking your jury, what I've seen is the folks there are okay with it. Now, rarely do you get a juror who wants to serve and wants to be there for 2 weeks, but once they get picked and they're sworn in, I find that they kind of settle in. They accept, okay, I'm going to have to make some adjustments in my life, but this is what I'm doing for the next 2-3 weeks. And they do sort of accept, and they take on that responsibility fairly earnestly, meaning now they want to do a good job. So I think if they've already sat in a courtroom together for a week, 2 weeks, by the time they get to deliberations, they're a little comfortable with being in a room with others, especially those others. And so I don't think at that point that they would shortchange their deliberations because they want to see it through. I've now sacrificed a week, 2 weeks of my life to hear this case. I want to see it through and render justice. Now, that's not to say that some juries don't rush through deliberations anyway. I mean, it's always concerning. For example, jury instructions get read at 4 p.m. on a Friday and you think, oh, great. What happens now? Does the jury come back on Monday or do they rush through? So that's always a concern. But my finding or feeling, at least anecdotally, is that once a jury is seated, even right now during the pandemic, they're going to be okay with it. They're going to accept it and really dig in.
Yeah, thanks, Rachel.
Rachel, just one more question, Rachel. You're doing jury exercises now and mocks. You're doing mocks. What are you seeing in the mocks in terms of, are they virtual mocks? Are you doing in person, or is it a mix?
We're doing both. At the start of the pandemic, when everything really shut down, it was solely virtual. But we're doing both now, and we have not seen a material difference in the types of people that are showing up for either. We're still getting representative cross sections of the communities that we're in, whether it's in person or online. So when you have one person who says, I'm not comfortable showing up to an in-person mock trial, you've got another person with the same sort of demographics and background that is. So we haven't seen a real effect of people being unwilling. That said, we're paying them quite handsomely for a mock trial. So some people might be more willing to take that risk, so to speak, versus in jury duty, the pay is usually minimal at best.
Great, thank you. Any final comments from the panelists?
Perry, I wanted to thank you very much for moderating today. I thought your questions were great and really appreciate you moderating.
Yeah, thanks so much, Perry.
Yeah, thank you, Perry.
Excellent job, Perry. From the folks at Magna Legal Services, I want to thank you, Perry. I want to thank you, Keith. You helped us make Magna webinar history. That's right. You're the first panelist that ever conducted a webinar from his car. Thank you very much. We're just going to go into our history books. Connie, in New Jersey, relative. Great to see you here. I hope to see you, off of exit. I'm not sure what exit you are, but I'm exit 4. And for those of you that are looking to host your next deposition virtually, we've got you covered. You heard Dr. Rachel talk about, the ability for us to host your focus groups and your mock trials virtually. We're doing a lot of witness preparation virtually as well. So virtually anything can happen at Magna Legal Services. So Perry, thank you. Enjoy the sun on the West Coast to you and Keith, and we'll enjoy the East Coast. And peace out. Thank you.
Thanks, Peter. Thanks,
Bye
everyone.
bye.
Bye.
Bye, Dr. Rachel.
Bye, Peter.
was
Take care.
great.
Stay safe.
Okay.